Dear students, this week we are going to discuss about one of the important WTO agreement, that is trade related aspects of intellectual property rights, which is popularly known as the TRIPS agreement. So, when we talk about the TRIPS agreement, it talks about intellectual property rights, and intellectual property rights came to the WTO system, or I would say that the GATT system, and as an agreement first time in the Uruguay round of negotiations. You can find certain provisions in the GATT, maybe a single provision, but the intellectual property was is continuously pushed by the developed countries from time to time through the different the trade negotiations, including the Kennedy round and the Tokyo round of negotiations. But as a full agreement, it came to the Uruguay round of negotiations for discussions, and many countries submitted their views, and they submitted, and developing countries specifically opposed a full fledged intellectual property regime within WTO system, because they argued that already the World Intellectual Property Organization WIPO is taking care of the intellectual property regime as such, and in some of the countries are members in some of the agreements like Paris Convention, and at the same time some of them are not members to other conventions like the Berne Convention, which talks about the protection of literary and artistic works, the copyright. They are not members, they do not want to become members to certain conventions. So, and we can see that this class specifically focus on. So, this entire week is going to discuss about the entire TRIPS agreement, its basic obligations and different categories of intellectual property rights, and also the minimum protection provided to each category of intellectual property law, and also we will see some of them, what can be patented, which is mentioned under the TRIPS agreement, what cannot be patented, and even provisions for compulsory licensing. So, we will see elaborately a little bit this particular agreement. This agreement is very important for any trade law student or anybody those who want to know about the agreements, WTO agreements, because this the intellectual property is exclusively dealt by this single agreement. And in this class we are going to see the philosophy of intellectual property, philosophy of intellectual property protection, and what is specifically the objective of TRIPS agreement, and what are the previous agreements which talk about different kind of intellectual property protection. And within the WTO, in the TRIPS agreement, there are 7 categories of intellectual property law. So, in the coming classes we will be discussing about the specific sectors of intellectual property law. So, when we look into the WTO, I already said that intellectual property came to the negotiations and completed as an agreement first time. So, it says the TRIPS agreement says that it want to facilitate trade. So, even though the developed countries want a full fledged intellectual property agreement, the developing countries were only agreed for like TRIPS agreement, trade related investment measures. Here it is trade related aspects of intellectual property rights. So, only trade related intellectual property is mentioned, not the whole intellectual property law is involved in TRIPS agreement. So, the agreement want to facilitate trade basically, and knowledge and creativity, because there must be innovation in the market if you want more and more trade. Then resolving trade disputes over IP, they found that the present the dispute settlement system under the WIPO is not very effective. So, they want a solid dispute settlement system under the WTO. Then and also this agreement wants to give leeway or gap or the freedom to every individual countries to set their own goals according to the domestic policy objectives. So, it means that the TRIPS agreement provides only minimum standards of protection, and it never gives a uniform law. It gives a minimum protection, and more protection can be given by the member countries in different areas, like whether it is in patents or it is in trademark or copyright, or it is geographic indications, or it is designs or integrated circuits, etc. So, every country is free to adopt their own policies, but according to the TRIPS agreement. So, one of the first cases was against India, that India is not complied with the TRIPS agreement, and finally, India was forced to amend its patent law 1970 in 1999, and in the same year for 99 or 2000. So, you can see that India passed so many legislations to protect intellectual property. They amended the copyright law, they amended the trademark law, and they come out with a new legislation on the protection of geographical indications. They come out with a new legislation of integrated circuits, and they completely revamped the intellectual property laws. Here you can see that the WTO, now this red color, which you can see that very few countries left to become the WTO members. There are 164 member countries are there in the WTO. All these 164 member countries has to implement the TRIPS agreement at the domestic level, whether it is a small country like Sri Lanka, or it is other countries like Nauru, or whether where your the size of your country is not a matter at all. Even small island countries also have to have a intellectual property law, and you also must have a intellectual property law. So, does not matter, you can have a higher protection, they can have a lower protection, but over and above the TRIPS agreement, you have to comply with the TRIPS agreement. This is the importance. All over the world, which deals with 99.9% of the world trade, have now to comply with the TRIPS provisions on intellectual property law. So, when you look into the philosophy of intellectual property protection, we can see many theories as well as many forms of protection. So, earlier you can see that customarily it was protected under the industrial property. We will see the Paris Convention, and then copyright law protection under the Berne Convention, which we can see. So, the many categories, we will see all 7 categories in detail, but this was the 2 main categories in the earlier times. And the WTO patent philosophy, which says that, or TRIPS philosophy, I would say, very clearly says, strike a balance between long term social objective of providing incentives for future inventions and creation, and the short term objective of allowing people to use existing inventions and creations. The short term objective, the short term monopoly is given to every inventors and every innovators for a period of 20 years in the case of patents. This is the short term, and so this monopoly for 20 years, in return you have to disclose the invention to the public from the very beginning, so that after 20 years the public can use this particular invention without any restrictions. At the same time, for a period of these 20 years, there is a monopoly rights over the innovator, which will give more incentives for further innovation. The famous incentive theory or sweat of the brow theory is famous as an objective of justification of protecting intellectual property. So, incentive theory is one of the prominent theory which is surfaced in the TRIPS agreement, and intellectual property protection is not new at all. From, I would say that from maybe even much before the 14th century, and the intellectual property protection is there in other countries, especially the European countries. So, it was recorded that in 1331 latest patents were issued in England, and 1474 inventors rights were recognized. Venetian Statute 1474. Then again you can see that the King James have recognized intellectual property first time in 1663, and 1760 you can see that the industrial revolution and the connected intellectual property protection was spread to other countries, whether it is Japan or it is US and other countries. And 1790 the US has come out, started giving the patents. France and other countries we can find the intellectual property protection. So, it is not with the Paris Convention that the first intellectual property law, international law was in place, much before that. So, the Paris Convention for the Protection of Industrial Property 1883 is the first comprehensive international agreement which protects intellectual property. And Berne Convention 1886, Berne Convention for the Protection of Literary and Artistic Works, which come up in 1886. So, it is after this it has gone back to some of the provisions in 1947 GATT agreement. So, I have already said that this whether it is a Paris agreement or Berne agreement or it is Madrid agreement, all these agreements were managed by the World Intellectual Property Organization, WIPO. WIPO is the specialized agency of the United Nations on intellectual property law. In 1995, the WIPO and WTO enter into a working arrangement, entering into an agreement. They said that to establish a mutually supportive relationship between them and with a view to establishing appropriate arrangements for cooperation between them. Now, these two WIPO agreements, many WIPO agreements, most of the WIPO agreements are a part of the TRIPS regime. So, the countries, I would say that the countries those who did not want to ratify the WIPO conventions, by signing the TRIPS agreement, they indirectly become members to those old agreements and regimes. So, here you can see that TRIPS agreement is not a single agreement. TRIPS agreement is a package which covers the Annexure 1C, which covers the Paris Convention, the Berne Convention, the Rome Convention, protection of performers, and also the broadcasters, other rights. So, the neighboring rights, then treaty to protect the integrated circuits. So, all these international agreements are now part of the TRIPS agreement. So, that is why I said TRIPS is not a single agreement, but it is a package of its old agreements. So, it is a package includes, which we talked about, is Paris Convention, Berne Convention, Rome Convention and Integrated Circuit Convention. So, the existing conventions and also the existing convention plus the TRIPS convention, TRIPS agreement. This constitute the present commitments or obligations. So, like any other WTO agreement, the TRIPS agreement says the objective is to reduce distortions and impediments to international trade, to promote effective adequate protection of intellectual property rights, and these measures and procedures to enforce intellectual property rights do not themselves become barriers to legitimate trade. So, if you look into these three objectives, it is very clear, other than the second one, it is a general one which is applicable to every WTO agreement, that is to remove distortions and impediments to international trade and helping economic development in developing countries. So, this is the common objective also which is incorporated in the TRIPS agreement. If you look into the TRIPS agreement protects 7 categories. it talks about 7 categories of intellectual property law. That includes patents, copyright and related rights, trademarks, geographical indications, industrial designs, layout designs of integrated circuits, undisclosed information or trade secrets. So, if you look into India, other than the last category, undisclosed information or trade secrets, India have specific legislations on each topic or each area. So, these are the 7 categories of the intellectual property which is protected under the TRIPS agreement, and we are going to see all these categories separately in the coming classes. So, if we look into the TRIPS agreement, you can see that basically IP is to be protected. The TRIPS agreement very clearly says that intellectual property is to be protected. And what intellectual property is to be protected? All the intellectual property which is mentioned in the TRIPS agreement, 7 categories to be protected. So, and if we look into the Uruguay round of negotiations, what is happened during the Uruguay round of negotiations, we can see that the developed countries were put a lot of pressure on the developing countries including India, but India also was a part of the negotiating team of TRIPS agreement, which submitted representations, which submitted papers and its views. And here the US has put a lot of pressure on the developing countries. So, the US practice was that the US will put the set of countries, those who are not complying with certain standards of intellectual property under the section 301 of the US statute. So, it is section 301, and even US can put sanctions on these countries under the section 301 provision, sanctions for not implementing intellectual property rights according to the US standards. So, we can see that this list, still this is the 2023 list. I was every year we used to see this particular list very eagerly. Fortunately, we are there from the day 1. India is there from the day 1. So, the earlier the countries list was very big list. Now, I think 2023 this is the shortest list which I saw, and the number of countries is limited to 7. So, it is surprisingly not the China at the first, it is Argentina, Chile. This year I do not know why the Argentina and Chile is there in the top, then China, and then always India, Indonesia, Russia, Venezuela. These are the 7 countries the US put under the special watch list under section 301. So, the effect is very clear. Under the US law, you can impose even sanctions before TRIPS agreement. Now, you cannot impose sanctions, but still the US continuing with this particular provision 301. Every year they come out with a list of countries those who does not implement intellectual property. So, still the US says that India is not implementing the intellectual property properly, but India says that we complied with all the provisions by amending our law in 1999 and enacting new laws in 1999 and 2000. So, these countries are still in the priority watch list of the US. So, the US can pressurize other countries to adopt measures. So, this is continuing. So, we already said that the agreement contains the general provisions, then standards, it talks about standards on 7 categories of intellectual property, plus it talks about anti-competitive practices and contractual licensing. And also you can see the agreement covers 5 broad areas. So, 1, the basic principles and connection with other international intellectual property agreements like Paris Convention or Berne Convention, and how it is going to be implemented. Then what kind of protection, what is the minimum protection to be provided in each category of intellectual property law. Then enforcement, that is very important, how the countries are going to implement it at the domestic level. Then settling disputes. The TRIPS agreement is under the WTO dispute settlement system, and transitional arrangements. Every country got, developing countries got 10 years, developed countries got only 6 years, and this transitional period is over by 2005. So, India again amended in 2005 its patent law and introduced process as well as the product patent system in the country. So, developing countries got 10-year period for implementing these particular provisions, and I think that most of the countries are implemented these transitional arrangements are successfully implemented by 2005 by the countries. And enforcement mechanisms also, you can see that every country has to arrange civil, administrative and also judicial measures. And in order to stop piracy at the border, you have to come out with the special legislations or special rules with regard to border measures at the border. Then in certain cases criminal punishment. So, you have to amend your criminal laws, for example, the copyright protection, geographical indication protection, criminal punishment. So, you have to make judicial arrangements, the jurisdiction of your courts. So, you can see the other provisions also can be there in the agreements, which provides for acquisition and maintenance of intellectual property rights, and disputes settlement, which we already said that. Then transitional arrangements is already over. Then institutional arrangements, which requires these tribunals, specialized tribunals and courts and other administrative mechanisms for the implementation. So, transition period is already over. So, we do not have to discuss more about it. But Article 7 of the TRIPS agreement very clearly talks about what is the objective of the TRIPS agreement. The objective under Article 7 very clearly says the IPRs should be contribute to promotion of intellectual technological innovation, promotion of technological innovation, transfer and dissemination of technology, mutual advantage of producers and users of technological knowledge, and also in a manner conducive to social and economic welfare and to the balance of rights and obligations of developing countries. So, if you look into the specific objective of the TRIPS agreement, it clearly says for the promotion of technological innovation. So, inventions and innovations are given the prime priority. Then 2, transfer and dissemination of technology, the transfer of technology, and mutual advantage of producers and users for technological advancement, economic welfare. So, all these are the specific declared objectives of TRIPS agreement, and the main areas of the TRIPS agreement, which you can see that the agreement sets minimum standards. Always remember minimum standards of protection, not the maximum standard of protection, and maximum standard can be determined by individual countries. Then the subject matter of protection. The subject matter of protection is determined under the 7 categories of intellectual property law. Then main elements of protection, the what is to be protected and what is not to be protected, what are the general exemptions which is mentioned under the TRIPS agreement. Then what are the rights conferred under the each category of intellectual property law. Then the minimum duration of protection is also mentioned under the TRIPS agreement. And under the compliance procedures, we can see that I already said that most of the countries, or the countries those who are not members of the old WIPO conventions, are automatically become members to the TRIPS agreement, and they are become members to the old agreements like the protection of the Paris Convention for the protection of industrial property, Berne Convention for the protection of literary and artistic works, and also the other agreements. So, substantive provisions of the earlier conventions are become part of TRIPS agreement. So, it is very simple that countries those who are not members of the previous conventions, they automatically become members to the previous conventions of WIPO. So, it is all these old conventions are a backdoor entry through the TRIPS agreement to the domestic laws of every country. Now, every country has to comply with the Paris Convention, the Berne Convention and other WIPO conventions. And the intellectual property enforcement is very strict, under the domestic laws, and you have to arrange civil and administrative procedures and remedies. The Controller General of Patents in India, the administrative mechanisms. So, the registration of trademarks, registration of geographic indications, the registration of the IC integrated circuits. So, and registration of copyright, very important, and then administrative tribunals and judicial systems to review of the decisions. So, enforcement is very strict with regard to intellectual property rights or TRIPS agreement. And the dispute settlement, so far 44 disputes came to the WTO relating to the intellectual property. I already stated that one of the first cases were against India for the non-compliance of the TRIPS agreement. So far 44 cases came to the WTO, a sizable number of cases. So, now non-compliance with the TRIPS agreement is also within the purview of WTO agreement. So, it means that any benefit accruing out of the TRIPS agreement is impaired or affected, or non-implementation of any of the WTO obligations, the members can approach the WTO dispute settlement system, or any legislation, domestic legislation of the country violates the TRIPS agreement, they can approach the WTO dispute settlement system and the WTO can decide the case. Non-compliance, violations, interpretations of the provisions and also the actions. So, the WTO dispute settlement system is very comprehensive with regard to the implementation of the system, the complete system. So, the obligations very clearly say that, remember, the TRIPS agreement gives complete freedom to the member countries to adopt their own practice, their own legal system, their own legislation, their own standard subject to the TRIPS agreement, which provides for the minimum standards, and the cardinal principle of national treatment principle is applicable. The national treatment principle is applicable to the TRIPS agreement as well. So, that means now the country is no more able to discriminate between the domestic industry and the foreigners or foreign industry or collaborative industry. So, all these include the availability, acquisition, scope, maintenance and enforcement of intellectual property rights. Now, there are so many intellectual property cases are fought in Indian courts, especially Delhi High Court, and even some competition involved cases like the Micromax case is entangled in the Competition Commission of India. The Google is faced a huge fines from the Competition Commission of India for violating Indian competition provisions. So, there is a new branch of law which came, intellectual property versus competition law. So, there is a sizable jurisprudence is coming up. So, that is also a one area of concern. The lot of the cases are also coming up. Then the MFN principle, most favored nation principle. So, if you give any kind of concessions to its member countries, you have to give it to others as well. One is non-discrimination principle, and other one is the most favored nation treatment principle. Both are applicable to the TRIPS agreement as well. Then when it comes to the public health protection, we will see the last the Doha Declaration on Public Health. The Doha Declaration on Public Health come out with certain concessions to the TRIPS agreement, and the countries those who does not have the manufacturing capacities and those who are facing pandemic and so on and so forth, the decisions taken in the 2002 Doha Declaration, Doha Ministerial Conference, that also we will look into. So, public health protection and also the socio-economic and technological development is also one of the objective which is mentioned under the TRIPS agreement. And the TRIPS Council, is in charge of the implementation of this agreement, the TRIPS agreement. So, all the member countries has to notify the TRIPS Council about its laws, regulations and practices, review of legislations, and also other activities relating to the intellectual property to be reported to the TRIPS Council under the WTO. And in conclusion, I would say that the implementation of TRIPS was not only path breaking, but it was a historic decision through the Uruguay round of negotiations, because the earlier the developed countries were pushing for the implementation of the intellectual property regimes, but the developing countries were very reluctant to implement. But the countries those who are not members to the international agreements, they are indirectly or clandestinely made party to all those international agreements which was pushed by the developed countries. So, but the TRIPS agreement objective very clearly says the incentive to inventors and the technology transfer and dissemination, and also the enforcement of minimum standards. Even though the TRIPS agreement provides the minimum standards, they only provide minimum standards, but the member countries to adopt their own policy standards, but still the developing countries blame the TRIPS agreement for the failure of certain sectors, like for example, providing accessible and affordable medicines to this sector because of the present intellectual property regime and the protection of intellectual property in such cases, medicines, access to medicines. So, TRIPS agreement is in total the first time came to the Uruguay round of negotiations and adopted it, and after the TRIPS agreement, so far we are is a quarter of a century, more than quarter of a century we are covered, and the TRIPS agreement is in letter and spirit implemented by the member countries. So, we will see in the next classes the elaborate the implementations and also the obligations under individual sectors in the coming classes. Thank you.